15th of June, 2022. Springfield, Illinois. The Department of Corrections updates its online roster at 9:17 in the morning. 7 names appear under maximum security housing. All women, all black, all serving sentences that end only at death. The files show a pattern: murder convictions between 1997 and 2017, scattered across 5 states, each carrying the designation LWOP, life without parole. Statutes promised finality. The dockets tell a different story. Appeals stretching decades, clemency petitions filed and denied, protocol challenges still pending review. In Tennessee, a single clemency grant in 15 years. In Texas, consecutive life terms with no parole date. In New York, DNA retesting motions filed 30 months after conviction. One woman was executed in 2013, the 500th modern execution in her state. The others remain. This is their legal record. These are the decisions that govern their lives. Illinois Appellate Court Opinion, People v. Hall, 2011, upholds LWOP sentence for fetal homicide, October 2006, East St. Louis, Illinois. A coroner in St. Clair County logs a charge unprecedented in Illinois criminal history: first-degree murder with fetal homicide. The victim, 7 months pregnant, was found deceased in her home. Prosecutors allege the defendant, Tiffany Hall, strangled her friend to steal the unborn child. Hall removed the infant via crude cesarean section. The child survived 3 days before dying. The case file shows Hall charged with multiple counts of first-degree murder. The trial begins in 2008. The defense presents psychiatric evidence. Hall suffered major depression and documented childhood trauma. A pre-sentencing report details years of untreated mental illness and poverty. The prosecution argues premeditation, citing evidence Hall planned the crime for weeks. The court finds the mitigation insufficient to overcome culpability. In Illinois, LWOP means life without parole, a sentence requiring permanent incarceration until natural death. Hall receives LWOP for each murder count. Her direct appeal is denied in 2011. No active post-conviction relief remains pending. Public reaction is immediate and intense. Media coverage frames Hall as beyond rehabilitation. Yet the trial record raises persistent questions about mental health access for impoverished mothers. Mitigation, evidence offered to lessen culpability or sentence severity, was documented but dismissed. The appellate opinion cites Hall's planning as overriding her psychological impairment. Illinois law at the time offered no middle ground between LWOP and a term of years. The question remains, if mitigation is documented but rejected, does justice still weigh context or only outcome? Tennessee Clemency Board Calendar, 2015, Moss petition denied, 0 female LWOP grants since 2000-2001. Memphis, Tennessee. Shelby County Criminal Court dockets a kidnapping and first-degree murder case. Pamela Moss is charged with abducting an infant from a shopping center and causing the child's death. Prosecutors present evidence of deliberate planning. The defense counters with psychiatric testimony. Moss has documented bipolar disorder and a history of medication noncompliance preceding the offense. An expert witness testifies that untreated mania likely impaired her judgment during the crime. The jury convicts on all counts. Moss receives LWOP in 2003. Her state post-conviction petition is denied in 2015. Federal habeas corpus relief remains pending as of 2023. She is incarcerated in maximum security at the Tennessee Department of Corrections. Clemency, the governor or board's authority to commute, pardon, or reprieve a sentence, represents the final legal safeguard outside the courts. Tennessee's clemency record tells a stark story. Between 2000 and 2023, the state received over 120 petitions from female LWOP prisoners. The board granted 0. Moss's petition appeared on the 2015 calendar. It was denied without hearing. The public expects clemency to reward rehabilitation and remorse. Tennessee's practice shows nearly absolute permanence. Families of victims often oppose clemency, fearing re-traumatization. Moss's case file includes written objections from the victim's relatives, citing closure and fear of release. The board's decision aligns with statewide patterns. If clemency is the last safeguard for correcting disproportionate sentences, why do some states use it less than once per decade? Department of Justice briefing, Racial Disparities in Female Incarceration, 2022, shows black women overrepresented in LWOP population by 3.1 ratio, 2022. Washington, District of Columbia. The Department of Justice releases a briefing on sentencing disparities. The data shows black women represent 7% of the national LWOP population, but only 13% of the U.S. female population overall. The overrepresentation ratio is 3-to-1. The briefing examines how race, socioeconomic status, and access to competent counsel intersect at sentencing. It references the Sentencing Project's findings. Women convicted of violent crimes involving children or intimate partners receive harsher sentences than men convicted of equivalent offenses, and black women receive the harshest sentences within that category. Appeal posture, the procedural stage where a case stands, determines what legal avenues remain. Direct appeal challenges trial errors and must be filed within strict deadlines. State post-conviction review examines constitutional violations like ineffective counsel. Federal habeas corpus provides a final layer of oversight for constitutional claims. Clemency sits outside the court system entirely, as an executive act of mercy. Each stage has distinct rules, deadlines, and success rates. Many inmates exhaust all remedies within a decade. Others remain in appellate limbo for 20 years or more. Special housing units, or SHU, and special administrative measures, known as SAMs, represent the most restrictive prison environments. Inmates under these designations face limited contact with other prisoners, restricted phone and mail privileges, and isolation from general population. Women categorized under SAMs often have ties to organized criminal activity inside correctional facilities. The briefing notes an additional finding. Mitigation evidence related to mental health, trauma, or abuse is presented in over 60% of female LWOP cases, but accepted as a basis for leniency in fewer than 15%. Courts acknowledge the evidence, then rule it insufficient to overcome the severity of the offense. As appeals slow and mental health mitigation is routinely sidelined, the question persists. Can the system still correct itself, or only confirm its own permanence? Ohio Court of Appeals, Opinion, State v. Greer, 2006, mentions postpartum once, rejects mitigation defense 2003. Cleveland, Ohio. Cuyahoga County Common Pleas Court hears a case of aggravated murder involving a child. Tashonda Greer is charged with causing the death of her infant daughter. The prosecution presents evidence of deliberate harm. The defense calls a forensic psychiatrist who testifies Greer suffered severe postpartum depression at the time of the offense. Medical records confirm her diagnosis. The psychiatrist explains how untreated postpartum psychosis can impair judgment and create delusional thinking. The trial transcript shows the term postpartum appears only once during sentencing arguments. The court acknowledges the diagnosis but finds the evidence of premeditation outweighs claims of impairment. Greer is convicted and sentenced to life with parole eligibility after 33 years. She will become eligible for parole in 2037. Her state post-conviction petition is exhausted. No federal relief has been filed. Ohio law allows parole consideration for some murder convictions, distinguishing it from states that mandate LWOP. Greer's sentence reflects this statutory difference. Mitigation, evidence reducing culpability, was presented through expert testimony but ultimately rejected. The appellate opinion emphasizes intent and planning, not mental state. Postpartum depression, though documented, did not meet Ohio's threshold for diminished capacity. The contrast with Illinois is notable. Hall's fetal homicide conviction carried automatic LWOP. Greer's infanticide conviction allowed eventual parole. Both involved maternal mental health crises. Both courts acknowledged psychiatric evidence, yet one state imposed permanence, the other delayed release. Why does one jurisdiction see illness as explanation, another as excuse? The answer lies in statutes, not compassion. Texas Department of Corrections roster entry, inmate Brown, shows consecutive LWOP sentences with no parole eligibility date, 2008. Houston, Texas, Harris County District Court processes a double homicide case. Tameka Brown is charged with murdering 2 individuals in a domestic incident. Prosecutors allege she acted with deliberation and intent. The defense investigates her background. A pre-sentence investigation report documents childhood trauma and years of domestic abuse. Brown's attorney considers presenting mitigation evidence at trial. Instead, a plea agreement is reached. Brown pleads guilty to both counts in exchange for prosecutorial leniency on additional charges. She receives consecutive LWOP sentences in 2009. The plea deal waives her right to direct appeal. No habeas corpus petition has been filed. She is incarcerated at the Gatesville unit of the Texas Department of Corrections. Her roster entry lists no parole eligibility date. The designation is permanent. Texas law allows plea agreements that bypass trial entirely. Brown's decision to plead guilty ended her case before mitigation evidence could be presented to a jury. The childhood trauma and domestic abuse noted in her file were never litigated in court. Her sentence became final the day she signed the agreement. No appellate court reviewed the proportionality of consecutive life terms. No clemency petition has been filed on her behalf. Texas retains the highest female LWOP population in the South, over 250 women as of 2023. The state's clemency board grants relief at a rate below 1%. If mercy depends on appeal, what happens to those who never file? Brown's case illustrates a legal reality. Finality can arrive before advocacy begins. New York Supreme Court filing, Lewis v. State, 2024. Motion for new trial, citing Batson violation, racial bias in jury selection, 2016. Queens, New York. Karina Vetrano, a 30-year-old woman, is murdered while jogging in Spring Creek Park. The case receives intense media coverage. Police investigate for months without a suspect. In 2017, Chanel Lewis is arrested and charged with first-degree murder and sexual assault. His first trial ends in a hung jury. The retrial in 2019 results in conviction. Lewis receives LWOP. He is incarcerated at Greenhaven Correctional Facility. No mitigation evidence was presented during sentencing. The defense focused instead on alleged procedural errors and DNA testing irregularities. Lewis's appellate team files motions challenging the conviction on constitutional grounds. In 2024, Lewis's counsel submits a motion citing a Batson violation, racial bias in jury selection. The filing argues prosecutors systematically excluded black jurors during voir dire, violating Lewis's right to equal protection under the 14th Amendment. Court documents show the jury pool's racial composition shifted dramatically after peremptory challenges. The motion requests a new trial. The New York Court of Appeals schedules a hearing to review the claim. As of 2024, the appeal remains pending. Federal habeas corpus has not yet been filed. The Vetrano family has issued public statements urging closure and opposing further delays. Their victim impact testimony, read in court during sentencing, described profound grief and the need for finality. Lewis's case differs from Greer's mental health mitigation and Hall's trauma evidence. Here, systemic bias replaces psychological argument. The defense contends that even if Lewis committed the crime, the process that convicted him was constitutionally flawed. The question becomes procedural rather than psychiatric. When conviction certainty meets racial doubt, can justice exist beyond perception? The answer may depend less on guilt than on whether courts are willing to scrutinize their own selection processes. Federal Bureau of Prisons report, Gang Coordination in Female Facilities, 2018, references inmate organizer Renatha G. in RICO-related case 2015 through 2020, multiple federal and state jurisdictions. A composite pattern emerges from documented cases in California, Florida, and Texas. Women incarcerated for violent offenses who maintain ties to organized criminal networks while serving their sentences. Federal investigators identify coordination of gang activity from inside correctional facilities. A 2018 Bureau of Prisons report on gang activity in female facilities references an inmate organizer identified as Renatha G. Court records show multiple women serving LWOP for conspiracy, assault, and homicide under RICO-related statutes. These cases involve ongoing criminal enterprises that continued after incarceration. Appeal postures vary. Some inmates have exhausted state remedies and filed federal habeas petitions. Others face overlapping state and federal charges still in litigation. Renatha Glover, a composite drawn from documented cases, represents women whose sentences stem not from singular violent acts, but from sustained participation in organized crime. Glover is incarcerated under special administrative measures, known as SAMs. These restrictions limit her communication with other inmates, restrict phone and mail access, and prohibit contact with individuals outside a pre-approved list. SHU, special housing units, provide high-restriction environments where inmates spend 23 hours per day in single cells. Glover's disciplinary record includes multiple infractions for coordinating activities through contraband cell phones and coded messages. Federal litigation challenges the conditions of her confinement, arguing prolonged isolation constitutes cruel and unusual punishment. Prosecutors counter that her ongoing criminal coordination justifies the restrictions. No mitigation evidence appears in Glover's file. Her case differs from Hall, Moss, and Greer, where mental health and trauma were central to defense arguments. Glover's appeal focuses on Eighth Amendment claims regarding conditions of confinement, not culpability. Her case raises a distinct question. If incarcerated individuals continue to direct criminal activity from inside prison walls, where does accountability end? If punishment extends to communication limits and isolation, who governs justice within the prison itself? Texas Department of Criminal Justice Execution Record, McCarthy, through 500, 26 June 2013. Notes clemency petition denied same day as execution, 26 June 2013. Huntsville, Texas. The Texas Department of Criminal Justice conducts the 500th execution since the reinstatement of capital punishment in 1976. Kimberly McCarthy, convicted of capital murder in Dallas County, is executed by lethal injection. Her case begins in 1997 when she is charged with the murder of a 71-year-old woman during a robbery. McCarthy is convicted in 1998 and sentenced to death. The conviction is overturned on appeal due to jury instruction errors. She is resentenced to death in 2002. Her federal habeas corpus petition is denied after years of litigation. Her final clemency petition is submitted to the Texas Board of Pardons and Paroles on the morning of her scheduled execution. The board denies the petition the same day. McCarthy is executed that evening. She is the first woman executed in the United States in 3 years. McCarthy's clemency petition cited her history of substance abuse and expert testimony regarding impaired judgment at the time of the offense. Defense attorneys argued her addiction constituted mitigation that should reduce her culpability from capital murder to life imprisonment. The board's decision offered no written explanation. Texas law does not require boards to justify clemency denials. McCarthy's execution stands in stark contrast to the cases of Hall, Moss, Greer, Brown, Lewis, and Glover, all of whom remain alive and incarcerated. The question of proportionality emerges. If McCarthy's substance abuse mitigation failed to prevent execution, why do similar claims occasionally succeed in securing life sentences instead of death? The answer lies partly in jurisdiction, partly in timing, and partly in factors the record does not reveal. If her execution marked a statistical milestone, the 500th, what does that say about whose deaths the system records as progress? New York Appellate Division Order, 2024, grants Lewis motion for DNA retesting. Hearing scheduled December 2024, 2024, Albany, New York. The Appellate Division, 2nd Department, issues an order in the case of Chanel Lewis. The court grants his motion for DNA retesting under New York's Post-Conviction Forensic Review Statute. The order schedules an evidentiary hearing for December 2024. Lewis's defense team has argued that advanced DNA analysis methods, unavailable during his 2019 trial, could provide exculpatory evidence or reveal additional contributors to the forensic sample. The prosecution opposes the motion, arguing the original DNA evidence was conclusive and no new testing is warranted. The court's order does not overturn Lewis's conviction, but allows the defense to present new forensic evidence at a future hearing. The Vitrano family issues a public statement following the court's decision. The statement, released through their attorney, urges the court to bring closure and opposes further delays in the case. The family describes the emotional toll of repeated hearings and motions. Victim impact testimony from the original sentencing emphasized the finality they sought through Lewis's conviction and life sentence. The appellate process, now extending 5 years beyond conviction, has reopened their grief. New York's post-conviction DNA statute allows defendants to request retesting when scientific advances might produce material evidence. Courts must balance the defendant's right to present exculpatory evidence against the victim's family's need for finality. The statute sets strict standards. Retesting is granted only when new methods could reasonably alter the outcome. Should scientific doubt reopen a case even when the victim's family pleads for finality? The law answers yes, but offers no guidance on managing the human cost of prolonged uncertainty. Tennessee Clemency Board Docket Entry 2023 lists Moss petition as pending recommendation, no hearing date set, 2023. Nashville, Tennessee. The Tennessee Board of Parole and Clemency dockets a petition from Pamela Moss, who has served 20 years of her LWOP sentence. Her petition argues that 2 decades of documented rehabilitation, mental health treatment, and institutional conduct justify commutation to a term of years with parole eligibility. Moss's prison record shows completion of substance abuse programs, anger management training, and consistent work assignments. She has maintained contact with family members and has no major disciplinary infractions in 15 years. Her petition includes letters from correctional staff, mental health providers, and a forensic psychologist who opines that her bipolar disorder is now effectively managed through medication and therapy. The victim's family submits a written objection to the Clemency Board. Their statement describes the ongoing trauma caused by the loss of their child and expresses fear that any reduction in Moss's sentence would undermine justice and re-traumatize surviving relatives. Tennessee law allows victims' families to participate in clemency proceedings through written statements and, in some cases, in-person testimony. The board's docket shows Moss's petition remains pending as of late 2023, with no hearing date scheduled. Tennessee's clemency process operates outside the judicial system. The board makes recommendations to the governor, who retains sole authority to grant or deny petitions. Between 2000 and 2023, Tennessee governors granted clemency in fewer than 5 cases involving violent offenses, none for women serving LWOP. Clemency represents administrative mercy, not judicial review. Courts examine legal errors. Clemency boards weigh rehabilitation and proportionality. Moss's case demonstrates the distinction. Her appeals exhausted years ago. Her conviction stands unchallenged. Clemency is her only remaining avenue for release. Yet the process lacks clear criteria, timelines, or transparency. If governors rarely grant clemency to LWOP inmates, does its existence only simulate compassion without delivering relief? The question remains unanswered as Moss's petition sits on the docket, pending review that may never arrive. Texas Legislature, Joint Committee Memo 2022, discusses LWOP sentencing reform. Illinois Governor's Office Review of Parole Eligibility for Long-Term Inmates 2022, 2022, Austin, Texas, and Springfield, Illinois. 2 state legislatures examine life without parole sentencing practices. In Texas, a joint committee reviews the fiscal and humanitarian costs of maintaining over 1,000 LWOP inmates, including 250 women. The memo notes that LWOP inmates age in custody, requiring increasing medical care and geriatric housing. Costs per inmate rise significantly after age 50. The committee explores whether parole eligibility after 25 or 30 years might reduce long-term expenses while maintaining public safety. No legislative action results from the review. In Illinois, the governor's office commissions a study of inmates serving sentences imposed before recent parole reform statutes took effect. The review identifies cases, including Tiffany Hall's, where mitigation evidence might warrant parole consideration under current standards, but existing law offers no retroactive relief. Tamika Brown, serving consecutive LWOP terms in Texas, and Tiffany Hall, serving LWOP in Illinois, represent inmates whose cases predate reform discussions. Neither has active appeals. Neither has filed clemency petitions. Their cases remain frozen at the moment of sentencing, unaffected by evolving policy debates. Illinois advocates push for victims' families to have representation during parole reform processes, ensuring that policy changes do not ignore survivors' needs. Victim advocacy groups testify before legislative committees, emphasizing that any reforms must account for the trauma and safety concerns of those harmed by crime. The tension is procedural. Policy reform can address future cases through new sentencing guidelines, but retroactive application, allowing old cases to be reconsidered, requires legislative action that courts cannot mandate. Can policy reform restore fairness without reopening every case? The question has no single answer. States approach it differently. Some jurisdictions apply reforms retroactively through resentencing hearings. Others grandfather existing sentences and apply new rules only going forward. Brown and Hall remain subject to the laws in effect when they were convicted. Their legal positions are final. Yet the policy conversation continues around them, debating whether permanence serves justice or simply reflects the limits of statutory change. Department of Justice, Bureau of Prisons. Incident Report, redacted 2023, Documents violence in federal women's facility, names withheld under Privacy Statute 2023. Federal Women's Correctional Facility, location withheld. A Bureau of Prisons incident report, heavily redacted under privacy statutes, documents a violent altercation involving inmates with suspected gang affiliations. The report is timestamped at 12:01 in the morning. Names are redacted, but the document references ongoing investigations into coordinated criminal activity inside federal facilities. The report becomes part of litigation challenging special administrative measures applied to female inmates. Defense attorneys argue prolonged isolation exacerbates mental health deterioration and violates the Eighth Amendment. The government counters that restrictions are necessary to prevent inmates from directing external criminal activity. The litigation remains pending in federal district court. Renatha Glover's composite case, drawn from documented patterns in California, Florida, and Texas, illustrates increasing scrutiny of SHU and SAM's policies for women. Advocacy organizations, including the American Civil Liberties Union and the Correctional Association, argue that women respond to solitary confinement differently than men, experiencing higher rates of self-harm and psychological breakdown. Department of Justice reports acknowledge these disparities but defend restrictions as essential for institutional security. The debate is ongoing. Courts have not established clear constitutional limits on how long women can be held under SAMs or what procedural protections apply before such measures are imposed. Victims of crimes committed by inmates under these restrictions are rarely named in public records. Privacy laws shield their identities. If punishment continues behind bars, if inmates subject to SAMs commit further violence while incarcerated, where does accountability end? The legal system offers no unified answer. The Sentencing Project report, Life Without Parole for Women, 2024. Shows women represent 7% of LWOP population, black women disproportionately affected, 2024. Washington, District of Columbia. The Sentencing Project releases updated data on life without parole sentences in the United States. Women represent 7% of the national LWOP population, approximately 4,000 individuals. Black women are incarcerated under LWOP at 3 times their representation in the general population. The report examines state-by-state disparities. Tennessee has granted no clemency to female LWOP inmates in 23 years. Texas holds the largest population of women serving life terms. Illinois has begun reviewing cases sentenced before recent reforms, but no LWOP sentences have been commuted. Ohio's parole eligibility structure allows eventual release consideration, distinguishing it from pure LWOP states. New York's post-conviction DNA statute has resulted in 3 exonerations of female inmates since 2010, none involving LWOP sentences. The report includes a list of known victims in high-profile female LWOP cases, compiled from court records and public memorials. The names appear alongside data on sentencing trends, creating a factual record that honors both those harmed and those punished. Advocacy groups hold annual candlelight vigils for victims of violent crime, reading names in public ceremonies recorded by local media. The Death Penalty Information Center notes that female executions have declined sharply since 2013. Kimberly McCarthy remains the most recent woman executed in Texas. No woman has been executed in the United States since 2015. The shift from capital punishment to LWOP reflects changing public attitudes and legal challenges to execution protocols. Life sentences have replaced death sentences in many jurisdictions, not because they are seen as more merciful, but because they are seen as more permanent. A photograph archived in court records shows an empty courtroom in Dallas County, Texas. The benches are vacant. The clock on the wall reads 4:17 in the afternoon, the moment after a verdict was read in a case no longer identified. The image is dated 2019. It has become a symbol in documentaries and academic presentations on sentencing policy. The silence after judgment, the permanence after decision. If mercy is policy, not emotion, if it operates through statutes, clemency boards, and appellate procedures, then understanding it is the first act of justice. The record remains, the names endure, the sentences continue.